Thank you all for coming. I'm Martin Kappenman. I'm an employment lawyer. I see some familiar faces in the crowd. I'm happy to see that. So I'm going to start by telling you what I'm not, because it's important in a difficult time like this that we not try to be something we're not. So I'm not a virologist. I'm not an epidemiologist. I'm not a physician. I'm not a disease specialist. But I'm a lawyer, so we're going to walk through all of the legal issues that you're going to see, especially with your employees. And there are huge changes. If you think you understand your leave policy, you're wrong, because it's going to change this week, probably change today. So, Emily, if we could switch this over to mine. There we go. I got it. All right. So some basics, right? Here are the basics that you all probably already know. This is the CDC's interim guidelines for employers. This is the recommended strategy. You're already doing this. You're actively encouraging employees to stay home if they're sick. You're separating sick employees. That doesn't mean they're sick and they stay. That means soon as you think they're sick, you remove them from the place where they're with the other employees and with your customers and send them home. You're doing your environmental cleaning, informing employees of possible exposure. And you'll see there consider ADA restrictions when doing so. From what I've seen is when you have, at this point, so when there is a confirmed case, the Minnesota Department of Health is going to be working with you if that person works in your business to handle that sort of notification piece with you. The general thing to keep in mind is typically under the ADA we try to avoid naming the specific employee to the extent you can. I think what you should avoid is a blast email out to everyone that says insert employee's name here. What would be probably more appropriate would be someone who worked with you on this shift has tested positive. That's the stage we're at now. All of this is shifting. But again, we're not going to identify particular employees typically at this time. Now, what's the reality of it, right? Everyone knows all the employees will instantly talk and figure out who it was, right? I mean, that's the nature of life. But as an employer, I don't think you want to be sending a notice that has the employee's name. And you're going to create an infectious disease response plan if you haven't already. These are the CDC's interim guidelines. So what's an infectious disease response plan? You're going to talk about identifying work-related exposures. So in the hospitality industry, it's clear to see how you could have exposures both with the public and with coworkers. You're going to review your employment policies. You're going to see if you can have some flexibility in those policies. A lot of talk about telecommuting, and a lot of that is totally useless to your industry, right? That's nice that everyone else can connect by online. You need to be there. But what you might be able to do is staggered shifts. Let's talk about that today, what you can do with respect to staggered shifts to keep people working. Efforts you can make to minimize exposure, social distancing, that sort of thing. And then a key element through all of this is proper communication with employees. If you don't already have a method to stay in touch with your employees, if they're not showing up at the work site every day, how can you get that done as soon as possible? So legal issues to consider. It's the interplay of all of these. You have the Minnesota Human Rights Act, the Americans with Disabilities Act, Workers' Comp, OSHA, FMLA, Minneapolis, St. Paul, sick and safe leave ordinances if you're in either of those jurisdictions, and countless other laws. There's the WARN Act if you're going to shut down. There's various rules and regulations. But the biggest thing is the brand new law. So over this past weekend, the House passed. The House passed. The Senate has not yet. The President has not yet signed it, as of when I started speaking this morning. The Families First Coronavirus Response Act. All right? This is a huge sea change to the law. I don't have slides for it yet because it's still not even enacted. But I want to spend a lot of time today talking about it because it's totally new. It's the one thing you have never dealt with. So what I could ask is, well, how many people in this room provide some benefit that provides 12 weeks of paid leave to all of their employees? And I think we'd see very few hands go up for that sort of thing. By the end of today, you might have that. Here is what this law is going to do. It is going to set up two different requirements. One program is going to be a 12-week paid leave at 2/3 pay. The other is going to be, as of the date of passage, 2 weeks of paid leave for every employer. It will be mandated. The interesting thing about it is it applies to those employers with fewer than 500 employees, which is approximately half of the workers in the country. There's talk that later that will be modified to make sure it covers everyone. And again, everything I say today about this Family First Coronavirus Response Act is talking about what the House passed. Now, based on the talk, at least late yesterday, the Senate was going to approve it in roughly the same form, and the President sign it. But we have to be careful about changes that will come. But it applies to even small employers. So now we're going to talk about, as we go through the day, changes for 50 and below. So the first question you're going to have as you all sit here is, how on earth are we going to pay for this, right? Yes. That's the question you have. It is supposed to be, the 12 weeks of leave is supposed to be paid for by the government through a refund or a credit of the employer portion of the Social Security tax withholding. Then there's talk. On top of that, yesterday, Kevin McCarthy, when he was on one of the morning talk shows, talked about how they've tried to put in there a mechanism where the Treasury Department, for smaller employers, will be able to advance those amounts for the leave, because even if the credit that you're paying when you pay your Social Security taxes, there's too many employers who won't be able to make the difference. You just don't have that type of money laying around your small businesses. So let's walk through the act step by step. So first, let's talk about what it covers.
This is the 12-week.
This is the 12-week. We're going to start with the 12-week. This is the paid leave bill for emergency leave pay. It covers these items. It's narrowly focused to be on COVID-19. So if you have a current diagnosis of COVID-19, you could be entitled to this leave benefit. If the worker is quarantined, and this is the element of it that's going to swallow almost everyone who wants to take it. The worker is quarantined, including self-imposed quarantine, at the instruction of a healthcare provider, employer, or government official to prevent the spread. It also covers any worker who is caring for another person who has COVID-19 or who is under quarantine related to COVID-19. And finally, especially important since the schools in Minnesota, all of them will be closed as of Wednesday, the worker is caring for a child or other individual who is unable to care for themselves due to the COVID-19 related closing of their school or child care facility. It's hard to imagine when you look at who can take the leave that everyone can't take the leave, right? Especially in a situation, and we'll talk about this later today, whereas employers, you're in a very difficult spot as far as how do you get your employees to say, well, come with any proof or medical diagnosis or anything like that, because the health system's too taxed, and we're going to talk about that generally. But that's who can qualify for it. So it's not supposed to cover every case of leave. It's supposed to be these 4 things. But what's the reality? The reality is with anyone who has any sort of medical condition is going to be viewed as someone who's at high risk, who should be quarantined. So really it's going to cover anyone who wants to take the leave, in my view, as currently written. So who's an eligible individual? Those of you who are familiar with the FMLA know to be in the FMLA world, you have to have 50 more employees, and for the individual employee, they have to have been with you for a year and have so many hours of work they've done. Here's the requirement for this new law. The eligible individual is someone who was working in the 30 days before they were impacted by COVID-19. So that's, if you've had this employee on your staff in the previous 30 days, as I read it today, and again, this is brand new, it doesn't matter if they were there for a day or longer. If it's within this 30-day period, they're captured by the bill. That's an eligible employee. So what's the benefit? The benefit that's at issue is eligible workers will receive a benefit for up to 12 weeks, and in any month in which they must take 14 more days of leave from their work due to a qualifying COVID-19 related reasons. Days in which an individual receives pay from their employer or unemployment benefits do not count as leave. So we're going to talk through the interplay between this new law and unemployment, because it's hugely significant and we don't know how those details are going to work out. What's the benefit amount? The benefit amount is 2/3 of the individual's average monthly earnings, up to a cap of $4,000.
Without tips?
That's a great question. It doesn't mention it. As I read the section, I spent much of yesterday trying to read the 100 and some pages of law. I didn't see a specific reference to tips. It's the type of question that they don't think about when they're doing things in a rush. So that's going to be hugely important to the hospitality industry, and we need that answer right away.
Net or gross?
Exactly. So the idea is it's going to be gross because the benefit amount is going to be 2/3. The benefits can be paid retroactively, meaning if someone's already been out, they may be entitled to this benefit, or as the benefit comes and gets up and running, they'll be entitled to the benefit. And they'll have up to 6 months after the enactment of this law to go ahead and apply for this. So it may apply for people who have been out already from your employment. A key piece of this is it is intended to be a protection of existing rights, including state and local paid leave benefits. It's supposed to be on top of all of these things. So you're going to have all of the requirements you already have, plus this whole new federal system that they're creating on the fly right now. There should be reduction based on receipt of state or private leave, so employees won't be able to double dip at the same time. The first 2 weeks of this leave that the employee is on, this new leave that they're just creating, they may be unpaid. So it's like before it kicks in, but the employee can substitute, if they have paid leave, they can substitute the paid leave they have during that 2-week period. And the employer cannot force that decision on the employee. That will be the employee's decision to make. The Secretary of Labor role in all of this has the authority to issue regulations to exempt small businesses with 50 or fewer employees, where the imposition of these requirements would jeopardize the viability of the business. So 50 or less may have this protection and may be exempted from it, put on the Secretary of Labor. Again, this is hugely important how this plays out today in the Senate, and then what happens politically with the Secretary of Labor. Such a huge number of employees are employed by people who employ fewer than 50. What are they going to mean by that? And we just don't know yet. Are they going to say, well, it would affect the viability of all 50 or fewer employers? Are they going to look at it on a case-by-case basis? Who on earth is going to look at it? There's no administrative state set up to deal with this system. There's a second part. So that's the first part of it. And we're going to talk a little bit about how it's supposed to be funded in a minute. The second part of it, this is in addition to this 12 weeks of 2/3 pay that employers will initially have to pay with the thought that the government is going to get them back when they pay their Social Security payments in. In addition to that, there is emergency paid sick leave imposed on all employers under 500 again, which is almost everyone in this industry. It requires all employees to allow employers to allow employees to gradually accrue 7 days of paid sick leave. So we have been arguing in these Minneapolis and St. Paul sick leave times, we've had a lot of discussion, a lot of burdens placed on this industry in those situations. Here's the kicker. And to provide an additional 14 days available immediately in the event of any public health emergency, including this current public health emergency. So what it's going to do is this week impose on all employers 14 days of paid leave they must provide immediately. What it also does is the law is written, the version passed by the House says, there can be no change to your current leave policy to adjust. So you can't modify, and this is a first because we've always told employers, yes, you can make your leave policy, make it clear that it's open to change. This law is passed by the House this week and says, no, you cannot. You cannot change that leave policy. You must leave your existing one in place and layer this on top of it, these new 14 days. What about part-time employees, right? Because it's the 14 days of leave. What does that mean? As written and passed by the House, it says, for part-time employees, it's the number of hours that such employee works on average over a 2-week period. All right, on average over what period? During what time of the year? All of these questions are unanswered as far as even that limited question. How much does a part-time employee get for a benefit when it's a 2-week period? How far back are we going to go? A new employee who's just starting out at a part-time basis, it's a real morass of issues. The paid sick leave, this 14 days, so this is separate from the 12 weeks. This 14 days is to ensure paid sick leave covers when school is closed due to a public health emergency, or if you or a family member is quarantined or isolated due to a public health emergency. It's on this 14-day period, there's supposed to be a reimbursement to small businesses, defined as businesses with 50 or fewer employees, for the cost of providing the 14 days of additional paid sick leave used by employees during a public health emergency. All of these are set up right now as supposed to be a temporary situation that ends on December 30th of 2020, right, at the end of the year. What we will see if this passes today or the next day is when can that realistically go away? I'm always concerned as an employment attorney. Certainly we're in a very troubling time, but it's also very hard once you have this out there, how does it ever get rolled back? And it's very concerning to me, and it's very concerning especially for these small employers. And we need a lot more detail, a lot more clarity immediately on how on earth anyone's going to pay for this. So what have they said? It's supposed to work through a tax credit system. A refundable tax credit for employers equal to 100% of qualified paid sick leave wages to be paid. Tax credit is allowed against the employer portion of Social Security taxes paid by the employer. So you would get a credit when you submit that Social Security. A reasonable question to ask is, well, wait a second, what if the amount I'm paying in for that withheld portion of Social Security taxes, that's far less than the benefit I've had to provide to these employees? My understanding from the bill I read this weekend is that extra amount is supposed to come back to you. So not is it just the amount you paid in, but it's supposed to be structured so if that amount is less than the paid leave you'd paid out, you would still receive those amounts. And there's the talk, again, it's hard to discern from the language of the bill itself, but the House Minority Leader said when he negotiated it in such a way that he understood that it would allow for payments by the Treasury to employers to make this possible. So again, we'll have to see how that all comes together. So with that, it's just a fundamental shift, especially in the hospitality industry, of how the employment relationship works. Because up to this date, very few, and I don't know of any, that have provided that extensive of a benefit. So how do you do that with a workforce, one who is not used to it, in a time of crisis that none of us are used to, in a time where you can't really request any sort of medical verification because of the stress on the healthcare system? It's going to be very troubling. Here's the other thing to keep in mind. These leave policies, imagine a stable workforce who can't come to work because of they're sick or they're caring for someone sick or their kids home from school. That's not the reality of the hospitality industry. Unfortunately, right now, in the hospitality industry, it's a shrinking workforce, right? Business is down, the number of employees you have is shrinking. If you haven't already, you'll soon be probably laying people off. Well, what on earth do you do with this sort of program, which would have provided someone 2/3 of their pay plus the 14 days, but you've got to fire them this week because you don't have anyone in your restaurant? How are employers going to work through that? That's a very difficult situation because I can imagine two different scenarios, and I don't know how it plays out. One, if the government is truly going to foot the bill, there's going to be an incentive to say, yeah, we'll keep you on and take the leave, and then you'll get at least the 2/3 of your pay for 3 months, and you'll get the 14 days. But certainly if the government's not footing the bill, no one's going to go down that route. And what restrictions will they put on that as far as how many employees you could actually have? Could you have a bunch of employees eligible for the Family First coronavirus response leave when you're not allowed to have people in your restaurant anymore? You know, how are those going to interplay? And what I like to have when I do these seminars is all the answers, because we know the law, we've seen all the scenarios. Now, we don't even know for sure what the law is, but it's too important not to talk about today because this totally changes everything. Totally changes everything. All the decisions we go through with respect to these additional slides are modified by this new system. And as we get to the end, let's return to this and we'll have some questions and try to think through different ways to address it. But now we'll kind of set that aside for a second, except to the extent that it touches on our other issues. So I put these hypotheticals together last week, and they seem almost quaint now, given how quickly the situation has escalated. So here it is. A customer enters your restaurant wearing a surgical mask. The customer's not coughing. They have no other obvious indications that they're ill. Your longtime employee, Fran, she's worked for you for 30 years. She's 68 years old. She says, I'm not going to that table. I'm old. I am at risk. I'm not going to that table. What do you do? Right? Anyone's thoughts from the group? Generally, what do you think people would do? I think generally what employers would do is say, friend, you don't have to go over there. We'll send someone else over there. I'll go over there. And I think that's fine because we're in an untested time. If someone says, look, I am scared of this and I don't want to serve that person because they're wearing a mask, and I read you're only supposed to wear a mask if you're sick, because we've been told time and time again, don't go out and buy all the masks. So to Fran, she thinks that's a reasonable fear I have. I don't want to go overwork in there. I think it makes sense to allow Fran to make that decision. Go ahead.
Do we view that as like, when somebody has a disability or an injury, we make accommodations for a bit of time? Because the federal government have said that that's a high-risk population, is it looked at kind of like that?
Yeah, and the question from the audience, and I'm going to do the annoying thing of repeating it because we have the video audience. So the question is, essentially, what we're doing is viewing this as a disability that's being accommodated. Now, it's not exactly the same, but is it similar to that? And I think that's a fair comparison, and I think that's really what you are left in a situation of doing, is trying to be reasonable, and to the extent it doesn't place an undue burden on your business, again, which is language from the ADA, which isn't directly applicable under the law to this sort of situation, it seems the reasonable thing to do. And does your response change if the customer is repeatedly coughing? Well, if our answer was already that we were going to accommodate Fran and let her not serve that customer, then it probably doesn't change. I think this week the question is, do you let that customer stay? You probably don't. You probably say, I'm sorry, given the current situation, we're going to have to ask you to leave. And I think, is that without legal risk? Of course not, because nothing in life is without legal risk. Someone may have a condition that makes them cough, but it's not related, and now I can't go to a restaurant. But the risk of that is so much less than the pandemic issue we're dealing with now. So I'd be very comfortable with you asking that. So here we have a different situation. Fatima is a relatively new employee. She's been working in your kitchen for less than 2 months. She has many family responsibilities and has not yet accrued any paid time off. Fatima, by all appearances, is healthy. Her 7-year-old son, however, has come down with a fever. He attends a local elementary school, which is known to have had a teacher who contracted the coronavirus. Fatima's co-workers approach you and demand that you send Fatima home because they are fearful they will contract the virus from Fatima. What do you do? So this is the situation that's very difficult, especially for employers who aren't able to provide paid leave, or if they do, employees who haven't been there long enough to accrue a lot of paid leave. What do you do? Again, the answer to this hypothetical is completely different given what I think the law will be by Friday, right? So by Friday, it will likely be that Fatima has 12 weeks of pay that she can take at 2/3 of pay, and she has 14 days of pay she's sitting on of paid leave that she can take to go home to take care of the kids. So that part of the hypothetical may be slightly easier if what it looks like will become the law becomes the law. What's likely to happen though, right? There's this whole issue, under 50, what's it do? When are you really as an employer going to know what the answer is? And they're going to make the law effective, it appears immediately. There's some talk that maybe it's 15 days it comes in. But there is going to be a transition period where you are making these decisions about leave, not knowing what the economic consequences are to your business. That is going to be a very difficult situation to be in. What I can advise, what you should be careful of, and it's always important, but especially so now, is careful documentation, right? Who was really supposed to be at work that day, especially in the hospitality industry where the schedules shift and change, because you're going to want to have a record of who wasn't scheduled to work, and so they're not in. Well, if you're not scheduled to work, generally you can't take PTO for a day you were never going to be there anyway, right? I mean, that's a funny way for PTO to work, or any of these leaves to work. So what are you doing to keep track of that? Because there's going to be lots of issues that come about as a part of that. All right, so let's not avoid the other issue that's posed by the question, because it's a hard one, right? We are trying to be an industry that is two things: calm and useful, right? Because that's the two things we can all try to be in a time of crisis: calm and useful. So we're going to try to keep our employees calm. We're going to try to be useful to the community and to each other. What do we do with this fear aspect? Where when you have a situation like this, again, it's not going to be this situation because the school is going to be closed by Wednesday. But a situation where employees, whether justifiably or not, view another employee as at particularly high risk. Right? That's a very challenging situation. The difficulty is, to your hospitality business, there is a huge risk of having someone who may be infected in your business, right? A risk to the public, a risk to your bottom line if you have to be shut down after that. So generally, I think what employers are going to do is be cautious and say, look, we're concerned about this, we're going to send you home. We're going to send you home because of this. But what you can't do is drive a business on rumor and fear, right? So you're going to have to try to understand if you're faced with this sort of situation where coworkers are approaching management and saying, we want some certain action. Well, what facts is this based on? We have to get to the bottom of that so we're not just jumping to conclusions and run totally on rumor.
Is it a confirmed case of corona, or is it just a rumor?
Yes.
Because if it's confirmed, aren't the rights different?
Yeah, so it's going to be totally different if it's confirmed, right? So if the son comes back and he has it, what's likely to happen based on my understanding of what's going on right now, and it changes all the time, is the Minnesota Department of Health is going to come in and make it very clear to you how this is going to work, right? You're not going to get to say, discuss it. But imagine a scenario. So here it's written, so the 7-year-old son, does the 7-year-old son have it? All we know is the 7-year-old son has fevers. If you've been around a 7-year-old, they frequently have fevers. We got a bunch of acetaminophen in our closet at home because kids frequently run fevers. So it's this area of uncertainty that's the hardest. If there's the actual case, it's going to be pretty clear what you do. This situation where, well, it's a one-off. So it's not someone living in the house has it. That's probably an easy situation for everyone. It's someone living in the house is sick who has some connection to someone who has it, but is it really that same virus, and you don't know. So that's the difficult areas of uncertainty you deal with. Here's another one. Again, written when you could go to Europe. John is a college student and part-time host at your restaurant who requests time off, sharing that he plans to take a spring break with his buddies to the country of Eurasia. Eurasia is not currently under quarantine or travel restrictions, but is on a list of countries the CDC has identified as currently being at high risk. What are your options? All right. So if someone wants to travel, who's one of your employees, what do? You give them all the information, right? And by this point, that information is out there. People are generally keenly aware of it, and it's shifting day by day. But if someone wants to travel, and maybe, this is written for a foreign country, but maybe it's to another region of the country that has a higher incidence of COVID-19, what can you do? Well, I think you tell them, here's the information. If they're coming to you, they're having that conversation, you tell them we're very concerned about that. But the person is free to go if they want to go. As an employer, you're not going to tell them they can't go. You're going to give them the information. But what you should tell them is if you go on this trip and you come back, and we have a reasonable concern that that's an area where you could have contracted this virus, you're going to have to stay at home and away from work even though you're back here and you want to show up to work. It's going to be another 14 days before you can come back to work. I think that's a reasonable approach for an employer to take at that point. And you're free to do that. There'd be no law that restricts that in my view. Here's another hypothetical situation. So it's interesting because last Wednesday when I wrote it, I made the employee a Chinese immigrant. Now if I were writing it, I would probably make them from Italy, right? That seems to be the area we're most concerned with now. But let's just walk through the hypothetical. Chen is a Chinese immigrant who works in your kitchen. He's been with you for 5 years, and while he's traveled back to China a few times to visit family, he hasn't taken any vacation at all in the last year or so, and you have no reason to think anyone he lives with has been traveling either. You receive an anonymous complaint from another employee stating that employees are uncomfortable working with Chen because they're afraid they'll catch the coronavirus from him. What do you do? Now this is set up to be one of the easier answers, right? What we're not going to do is we're not going to discriminate on people based on their national origin, their ethnicity, those types of things. So that one's an easier one. You have to reassure them the fact that someone is Italian or Chinese or wherever it's most prevalent tomorrow. That's not why we're going to take action as far as sending someone home from work. But what if it changes? What if they've recently traveled to an area where there's a lot of infection? Right? Then I think your answer can change. And you can say, look, just like we were worried about John who was making his trip, we can say, we're concerned about this travel because you're in an area where there's an outbreak and we're in the hospitality industry. In this difficult time right now, I think you're empowered to say, look, to that employee, they should stay home. So here's one. Rachel is a longtime server at your restaurant. She's the consummate professional, never coughs or sniffles in a front of the house location, and is the most sanitary person you know. Using a pump of the hand sanitizer station you've provided every time she comes or goes in the kitchen. However, you've noticed her looking a bit peaked and coughing and sneezing quite a bit into her elbow and away from other employees in the kitchen. You've approached her about taking some time off, but Rachel insists she's fine and needs the hours. What do you do? Again, last week when I was talking to employers, this was the big issue. Employees wanted to stay, employers wanted to send them home. Given how things have progressed in the past few days, I think the answer is pretty clear. You send Rachel home at this point, right? I mean, this is, again, not a difficult one. The next question is interesting. Can you require Rachel to allow you to take her temperature? Thoughts? One, my first thought is, why on earth do you want to be, now you're taking people's temperature? I mean, you got enough going on. You do not want to be in the business of taking temperatures of employees. It's not where you want to go. The interesting thing under the law is the law that normally prevents that is the ADA's restrictions on medical tests. So taking an employee's temperature is a medical test that you're only allowed to do under very special circumstances of any medical test.
A national emergency?
Exactly. So under the ADA, there is a provision that says in a pandemic, you can take other steps necessary. So everything I've read up until yesterday, all of us employment lawyers have been saying, still, we don't know, medical test, we don't like the temperature taking. But in the EEOC guidance, what it does is it compares it to some of the previous outbreaks, the H1N1 swine flu, those sorts of things, and said, well, if we were in a situation like that, maybe you can. Well, we're far beyond a situation like that, right? So although I can't say definitively, yes, you can take the temperature of employees, boy, it sure seems like it's moving in that direction. And that's something that I think you might be seeing in your industry as time goes on. Now, I still question how effective that method is, and I'm not going to play doctor, but if you can take things that temporarily reduce your temperature, I don't know how that really fits into your program, but it's something that is out there. Here's the other thing. Can you require a note from her doctor? All right, we're going to have this issue right now about the medical system, right? And it's under stress. So I put this on here because generally we work a lot with employers saying, all right, you're going to have to require documentation of medical issues, right? Because you don't want things to get out of control. You don't want employees to take advantage of you. The reality is right now, you can't be sending employees to get medical notes because the system's going to be, if it's not already, under too much stress, right? So that creates a lot of difficult problems that you're going to have to address on a case-by-case basis. For example, think through this issue. You've got someone who's out on workers' comp, right? And what do? You generally require a note for them to return to work because they've had this injury. You're very concerned that they're going to come back and then they'll re-injure themselves or pretend they've re-injured themselves. All of those issues employers have to face. Typically, you would need medical certification to come back. But you're in a real tough situation now because I think the employee will plausibly be able to say, well, I can't get a doctor's note. Now, my hope is that there's enough business still in the hospitality industry where you're worried about employees coming back to work. But why else might the employee want to come back to work? Because now there's a benefit the federal government is giving where you get 2/3 of your pay for 12 weeks. So everyone who is in this system, if it's not paying as well, might want to migrate back into the employment situation so then they can migrate back on to the 2/3 pay of the 12 weeks leave.
Is it 12 consecutive weeks?
No, it's piecemeal. So it envisions coming back and forth and having to leave and have to come back. Similar to the FMLA, which if any of you who have dealt with that, there can be intermittent leaves. The leaves can be for a period and come back for a period. So here's a slide we need to spend some time on, and this is the worst part of this industry, this virus, and these legal issues. Paul Bunyan's Blue Ox Burgers is a beloved local restaurant. Unfortunately, due to an outbreak in the local area, business is slowed to almost nothing. In order to cut expenses and survive the downturn, the owner has decided to close the restaurant for 1 week. Several of the employees asked Paul if they can use their PTO during the 1-week shutdown. Paul's restaurant is in a very difficult financial situation and would like to avoid the expense. What should Paul do? And then, as the second question, Paul's salaried management staff will be working the first day of the shutdown to catch up on paperwork. Does Paul need to pay those employees for the entire week? Right? So the unfortunate reality is lots of small employers and large employers in the hospitality industry are going to be facing some version of this. Either there's too little business to stay open, or the public authorities say you can't stay open, or you can only stay open for takeout. What can you do? All right? So again, in the past, once employees are terminated, if your leave was set up that upon termination, they don't get it paid out. It's not a paid out when you leave system, which you were free to set up, where PTO isn't paid out when someone leaves. What the situation would have been is the employer terminates the employee. Imagine it's going to be a longer shortage, not just the 1 week. The employer terminates the employee goes to unemployment compensation, and that's how they get living, get the money to live until they can get their next job. That's how the system's set up. A 1 week shutdown, typically you wouldn't be eligible for unemployment compensation, right? So as of last week, if you went in and you said, I've been unemployed for 1 week, I want my unemployment compensation, no, there's a week waiting period. So you're not going to get it. So they're going to come back to work. They're going to be out of work for a week. Generally, in my view, if the place is closed, that's not a time where you can take PTO because, well, PTO is for when you were going to be working. Now, there could be some debate about that. So I would have said, look, you don't have to let those employees take leave during that week off, and they can come back the next week. Obviously, a lot of this changes based on this new law that might get passed today. And how, as we're going to have to think through and start thinking through for yourself as we get more details this week, how are we going to deal with that issue of layoffs combined with this new federal benefit and how to do that dance? So here's the other thing that needs to happen, and there's talk about it, but as of yesterday when I was preparing for this, I haven't seen it yet, is What changes are going to be made to the unemployment compensation system to make this all work? And in my view, for it to all work, especially for this industry, there has to be benefits that kick in on the unemployment side equal to these FMLA leave ones, or we're going to create a real dilemma for employers and a real difficulty as far as which way to jump as workforces are drawn down. So that's what we will see, is a change in the unemployment compensation, and I think we'll see that here in the next week or two. So keep that in mind. Let's go to the second part of it. And this might be some of you people in this room as employees. Paul's salaried management staff will be working the first day of the shutdown to catch up on paperwork. Does Paul need to pay those employees for the entire week? And the answer is yes. Exempt employees who work any part of a week have to be paid for their entire week's worth of pay. All right? So that is something that surprises people. And what you can do as an employer is say, yeah, but the way you're going to be paid for that week is you have to use up your PTO. You can do that. You can say, yeah, you can get paid, but you have to use your PTO for those other 4 days. But what if the employee is out of PTO? And this is the weird situation where the employee who's saving up their time is punished, because the employee who has used up all their time, you have to pay them for the days. And this is salaried employees, exempt employees I'm talking about here. And
non-exempt salary?
so if you're non-exempt salary, you should fall into probably under the non-exempt rules, where you probably wouldn't have to pay those folks. Now, I always get worried when I hear about non-exempt salaried, because boy, that's a tricky thing to do well. So think about that as a bigger overall issue. The one thing you would think is, well, come on. In the midst of this crisis, who's going to really notice that this exempt employee didn't get their 4 days? We're all in tough times. It's actually, interestingly, when you go to the emergency question and answer under the FLSA, it's one of the first things they talk about. So your employees all have access to that, so they may be aware of that. And what it's hinting at is, the Department of Labor is still going to take those sorts of pay things particularly seriously, even in the midst of all of this. Other considerations. So federal law, there's something called the WARN Act, and it was set up essentially for closing factories down. And it said if you're going to close your factory down, you got to give the employees 60 days notice when you can, and if you don't give the 60 days notice, you're going to end up paying the employees for all of the days that you shut down with less than 60 days notice. Again, the federal law, and there's a Minnesota counterpart, but it's 100 employees. So that's something that generally, when there's reductions in employments, massive closings, you have to consider. Now, the thing to keep in mind, if you just hear about that one, is that one, although we need to be aware of it, doesn't particularly trouble me, because there is an exception for unforeseen economic circumstances. Well, this is that, right? This has to be an unforeseen circumstance. But what does it remind you to do? It reminds you that communications with employees are vital. So throughout this whole process, you're going to want to make sure you're communicating with your employees. Because as of today, they're going to hear all of this on the news about this 12-week leave system and all of that. It's going to be a nightmare for you to answer questions about that, because we don't have all of the answers yet. So what can you tell employees? You can tell the employees is, look, we're doing everything we can to learn about it. It's a rapidly evolving situation, and we'll keep you informed as far as how it's going to affect you here. That's all you can do. Yes?
What is the minimum amount of time that an employee has to be out of work in order to claim unemployment?
Yeah.
They can't if they're out for a week.
So the question is, what's the minimum amount of time an employee has to be off before they're eligible for unemployment? So generally there is a week waiting period. So generally, if you fire someone, it's a week before it can kick into the unemployment. Now the important thing to remember for employers is that you should advise go ahead and file for unemployment right away. You know, don't wait the week, go get your paperwork filed, do it online is how you can do it now. The system will kick in the waiting period. It will build that in. The other thing to keep in mind, and it's especially important in the hospitality industry in these times, is unemployment compensation is available for people who still have jobs. So if your work is reduced, if you normally work 40 hours a week or almost 40 hours a week, and there is an event at your workplace or a change in the work situation that your hours are drawn below 32 hours, you can still be eligible for unemployment. And that's not new, that's not a development, that's been the case here in Minnesota.
Can we ask them if they filed for it so they don't double dip? Like, how are we going to know?
Yeah, so you'll know that they've filed for it because you will be alerted by the state. Because when they file, it will kick into the system where the state is then reaching out to you to confirm whether they're eligible for unemployment. Because imagine a situation where, well, they say they're eligible because they're out because we're slowed down, but they're really stole a bunch of things from the kitchen. Then they would be ineligible. So you'll be part of that process and know. There'll be somewhat of a delay, and rest assured, given these times, the delay will be longer than it typically would be. But you should know in a way that can prevent that. And again, on the, it's essentially a temporary layoff. So that's the sort of thing, if the hours are reduced too much, it can kick into that system. So then the thing that employers necessarily are always worried about is, boy, my ratings for all of this are going to be really affected. And again, part of the fix is going to have to be dealing with this because that's the situation you're going to find yourselves in. All right, we'll move to the next hypothetical. Your restaurant has had a number of employees calling sick. Sue works the lunch shift. She feels great and is ready and willing to come in for a regular shift. Her children's school is closed as a result of the coronavirus outbreak. Sue calls in to tell you she will not be able to come into work today and will be taking PTO. What do you do? Would the answer be different under the Minneapolis Sick and Safe Time Ordinance? Minneapolis Sick and Safe Time would say a school closing, you have to allow the person to take it. You can't really ask any questions when they ask to take it anyway, so basically your hands are tied. They're going to take it for whatever they want anyway. So that's that answer there. And then this hypothetical, again, was drafted before we have this whole new regime which is in place. So that's going to affect what you do on that. So what we had talked about last week with some employers I was dealing with were an infectious disease policy, and perhaps you'll see in the bold there, well, maybe what you do, look, it's a tough time for everyone. It's a tough time for employers and employees. Maybe you add a little extra paid leave time at this point to help people out. Boy, don't do that now. Don't do that today, because whatever policy you're going to make under this new law, you're going to be stuck with. So certainly I would think this week is not the week to voluntarily be changing your policy to make it more generous. Now there's few employers in this business who were in the spot to do that anyway, but some maybe were. Well, you got to hold up and see which way this, how this law shapes up. So what I want to do is, and it's built in here, a lot of time for questions. I'm not going to have the answers to all of them about the new law, but let's hear questions the group has. Yes, go ahead.
What if you go with a furlough program? Because we think this is very temporary and we furlough our employees rather than lay them off and terminate.
Yeah, so the question is, what about a furlough program? And how will that work? So I'm imagining a furlough program where, all right, for the next 2 weeks you're on and you're working, and then we'll switch, and for the next 2 weeks the other half of the staff is working. Is that something like what you have in mind? Yeah. So as you think through that, again, under the current law, you'd say, all right, well, those people might be eligible for unemployment even during the furlough, because now we're getting to a time period where it might apply. But beyond that, the issue is going to be all about, all right, the people who are on furlough are not going to be eligible for this new 2/3 pay benefit. They're also not going to be eligible to use their 2 weeks of vacation or PTO time. So how receptive are they going to be to a furlough program now once it's clear that, well, no, if I weren't furloughed, I could be getting 2/3 of my pay because, yeah, I got kids at home sick, or I got a pre-existing condition, a lot of that. So what it does is it still makes it possible, and it makes it a system you can use. It just adds to the complexity of it, because you're going to have to contemplate employee buy-in. Before, when the option was you're going to be unemployed, everyone would be for this furlough, right? We're going to work through it together. We need you to survive. Boy, it's going to be more complicated under this situation. Another question employers have that kind of relates is I-9 compliance, because all of the old problems you had are not going away. They're going to be added onto in addition to this. So generally, if it's a term of leave where you expect the person to come back, you don't have to kick in the whole I-9 process again, right? So if you're expecting the furlough and then they're going to come back, don't think you have to do another I-9. That's not how that system's supposed to work. They should be able to maintain under their current I-9. And just because I mentioned for years now, I've been talking about this, when ICE shows up, and they're still showing up. Last week we had many clients of ours who ICE showed up and were doing an audit. And ICE said, we need all of your I-9s in 72 hours. That's how the law works. You have to give them in 72 hours. What you should be able to do as an employer is respond to that in 72 minutes, because your I-9s should not be in your personnel files. Your I-9 should be in a separate I-9 file where you keep them all together. So if you haven't done that yet, think about that. Just kind of to finish out the story, on when Friday came around and we were ready to turn over the I-9s, ICE's office was closed because of the pandemic. So they did extend some extra time. Other questions? Yes?
What's the difference between firing someone and laying them off? And is there a better choice? Because obviously this is hopefully temporary.
Yes. Yeah, it's a great question. So the question for the video audience was, what's the difference between firing someone and laying someone off? So under the law, the difference has really disappeared, because the term layoff, again, applied in a different time where there would be factories that would get slow and they'd lay people off knowing they'd come up. Generally, I advise employers never to use the term layoff when you mean terminate, unless you're sure the person's going to come back. It's a separation from employment, and there's no judgment attached to that. It's not like you're fired for cause or because you did anything wrong. Look, you've been separated from employment. So what the question is then is, well, what if we don't know, right? That's the tricky thing today, is I don't have any more hours for you to work, Joe. You're a great employee. I want you back a month from now when everyone's going out to eat every day because they've been pent up inside with their crazy kids for a month. So what do you do? And I think there needs to be some nuance and appreciation of the benefits. So my thought is, you're going to, for most folks, maybe by the end of this week, we'll have a little sense as to how long this is going to work. But what you'll tell them is, we don't have any work for you right now, right? And they'll be able to go to the unemployment and say, I don't have any work right now, and that'll kick that in. Then the question becomes, with existing benefits, COBRA notices. When do you have to get COBRA notices out, and all of that? And my thought, you're going to have to work with your benefit provider on that, because that's a shifting scenario. But boy, I think you're going to have to do an assessment. How likely is this person to come back quickly? And certainly you can move down the road as though they're not going to come back. Talk to your benefit provider, see if they should send the COBRA notice so you can be in that system. And then if you call them back good, you don't have to do the rehire paperwork, you don't have to do the I-9, they'll just be brought back in. But what a long way of saying that is, for the most part, we can avoid making the determination because we just tell them, well, for right now, we don't have any work for you. And if they say, how long is this going to last? Our answer is probably, we don't know. And there's nothing you have to do beyond that, probably at this point. So I think we're going to make everything work so we keep open those options. I just don't like the term layoff because it implies that we know for sure you're coming back, and none of us do right now. Yes?
So I'm going to build onto that question. So we probably have, I don't know, 650 hourly employees, of which a third have benefits.
Mm-hmm.
And there's a lot of nervousness. Pretend like we shut down, and I don't think it's a 2 weeks from now thing, but pretend like we shut or partially shut sometime this week. There's a lot of nervousness, like what happens to our benefits? Do these times count for my hours to be benefit eligible in the future? This question of are they still an employee or are we putting them on leave is a big difference, right? If we go and trigger COBRA for them as a Pizza Blue Chain employee, they're paying $60 a month for health insurance. If we COBRA them, they're paying $200 and something a month for insurance. So these are actually really huge questions that likely at some point this week or next week we'll have to start talking to our employees about.
Yes.
Some subset of our employees. So I don't know if there's
so
your advice we could have?
the question is, what do we do for employees where we have, and in this case the person asking the question has a large workforce, what do we do when we're essentially saying people, you're not going to work right now, but we don't know if we're going to bring you back, and in particular how it deals with benefits, because when you're an employee, you're getting paid, receiving the benefit the employer is going to provide, which greatly reduces your costs compared to COBRA. So that's the question. One thing I point out, the person asking the question mentioned they have over 600 some employees. So now, strangely, as of the bill drafted today, you're not in that.
Am I not? They're spread across 9 different federal IDs.
Okay, well, there you go.
We do 9 separate things.
Yeah.
I think we're 10 employers under one trade union.
Yeah, so then there's another issue with respect to those operations that have more than one entity who employs people. Will they be viewed as separate employers for the 500 or 500 employer test, or will they be viewed jointly? And that's not a new issue. That plays into many other laws as far as various responsibilities in FMLA and various other laws. So there's the test as to whether they're truly separate employers or not. And there's issues that you would already encounter with respect to, and the answer might be, well, when people work currently and they work for both places, do they get paid overtime when they're working for the second place over 40? And if you already are paying them overtime, that might be your answer to how that works. With respect to the benefits, so I think what it is a huge financial decision that the business is going to have to make, right? Because the real question is, can you afford to keep these people on your benefits who are no longer employed? So maybe it's an easier question for March because you're probably, for the month you're in, you're probably on the hook for paying the benefits for that month. Typically that's how it works. As we get closer to tipping into April, boy, that's going to be a huge decision point for employers as to how they're going to manage that in a very difficult time. Other questions? Yes?
Kind of on that same line, you mentioned in the Act, which is before the Senate, you mentioned what happens in the case of business closure, and do they make a distinction between voluntarily closing or forced closure?
Mm-hmm. Yeah, and I don't think they will look at as far as why the business closed. Did the business choose to close? So the question was, what about a voluntary versus a forced closure? So if I'm trying to tease out, the question is, are you imagining a forced closure by the government? Okay, so that's the question, is what if the government comes in and shuts you down? We're a little bit in uncharted territory there, of course. My sense would be it wouldn't matter why you shut down. If you shut down because there's no customers and you shut down, or you shut down because the government shut you down, my guess is with respect to the obligations to your employees, they will be the same, both under this new law and under existing law. So just some other things to keep in mind in this situation is, all right, what about all of your contracts, right? So as business people, you're thinking through, what contractual obligations do I have to various places? In the legal world, there's lots of talk about force majeure clauses, right? So that's the paragraph in there that says, well, if there's some disaster, we're both off the hook from this contract. So think through what that means. Look at your contracts, review them carefully. You're also going to have to prioritize probably who you're making payments to. So as we do that and we prioritize who you make payments to, vendors who are essential for your continued operation, obviously are at the top of the list. I'm not telling you anything you know. And employees should be at the top of the list for two reasons. One, you need them to come and work. And two, all of the penalties for not paying employees really ratchet up. And in some circumstances, if the facts are right, that can be personal liability to the small business owner. So boy, when you're prioritizing all of those bills, the employees' payments have to be right at the top. Yes?
I'm trying to get my head around this. We close the business, they're eligible for all the government aid, whichever one,
Yep.
maybe both. But are they still employees? So do they still maintain their benefits? I mean, are they still employees?
Yeah, so if the business is shut down, the question is, are they still employees? Well, the question is, are you going to still, if you have benefits you provide them, as an employer, are you in a position to continue to make those benefit contributions? My guess is for most places, all except the very largest, if you've been shut down, you're not in a position to make that employer portion of whatever contribution you were making. So you're probably shifting into a realm where those are now people who are no longer employed. Regardless, the day you're shut down, they should be applying for unemployment so they can start to kick into that system and get that paperwork rolling. Now, with respect to this new benefit, how is that all going to work? Is it going to be paid leave that you have to pay out upon termination or not, and how that dance all works? But I think during the month, it becomes easy. It's not as hard of a question as once you roll into April is when it becomes a very big question. If are you still going to make contributions to employees for their health benefits? Yes?
Oh yeah, I think maybe she was getting more at just with the 12 weeks of 2/3 pay.
Yes.
If that's the route, with the bill that passes that people end up going, are they still going to be employees for those 12 weeks?
Oh, yes. Okay, good question. So the question is, imagine a scenario where we're under the new law. It passes today. You're in the 12 weeks where you are under that sort of that new, what I'll call new FMLA. Yes, they're envisioning that they would still be employees. What I'm telling you is, so they would still be on your payroll, you would have those obligations, you would keep them there. What we don't know yet is how FMLA, unemployment compensation, and business shutdowns, how those three are going to work together. And that's what we need very clear direction from Washington and the state of Minnesota this week. We need it now as far as how do those three things work together. Because again, as I read the bill, it's imagining this magical company where all the employees can't show up, but there's not layoffs, there's not terminations, there's not any disruption in employment. Yes?
Again, it feels like it's likely this week that most of us are going to be making decisions to either drastically reduce in a planned way
Yep.
our scope of service and or shut our doors, and they just got sent a list of other restaurants and things that are already closed, retailers that are closed. What advice can you give us, given that we know nothing, and also that we're small businesses? I mean, I feel fortunate enough that I have one HR person, and there's several of you in here don't have anybody who's doing HR, and there's such an enormous amount of things to keep abreast of while your employees and your managers are asking you 5,000 questions.
Yeah.
So kind of in that landscape,
In
what's
that,
our best?
yeah. So the question is, in a landscape where this week, today, we will have to make decisions that before we know how this is all going to play out, it would be nice if Washington gave us all the answers. They won't. How do we respond? It's very tricky because the answer may change by the end of the day. But my general answer is, it doesn't do employees any good if they work for a business that's bankrupt, right? You can't help them in any way. So what you have to do today is take the steps necessary to have your business survive, which especially for the small business is to look at it financially and say, what's the least expensive way forward? Because all our customers are gone. And if we look at the least expensive way forward, there's great uncertainty because of this new law, and we don't know if the government's going to pick up the tab for all of that. But generally, what we see, so I think back to when things were really bad in 2008 and we were advising clients. The recommendation was mostly to take action quicker. Places, especially who had long-term employees, were very reluctant to make the move to reduce the size of their workforce. I think you need to start moving in that direction quickly. As far as your messaging to employees is, probably right now, look, we're going to reduce the workforce. We're not going to need you to work again. And then when do you really need to make the decision as far as whether this is a separation from employment? And for a lot of people, it's going to be next month. In the back, yes.
In order to maintain some cash flow for obviously times to come, there's a sales tax bill about to come and some payroll tax about to come. And like my initial reaction is I'm not going to pay them because I need that cash flow for next month. Is there going to be some leeway from the government to, I don't know, if they talked about anything to do with that to help, in our industry, like to say, hey, you got a month's leeway on your sales tax or your payroll tax, you can hold off to pay that, or even just talking about mortgages and rent. I don't know if you know anything about that.
Yeah. So the question is, what about relief from taxes that they do? Be they sales taxes, payroll taxes, all of those types of things. How do you juggle that, and how do you deal with the issue of mortgages and rent and all of those things and juggling those payments? So is there talk about, yes, suspending the payroll tax? There's lots of talk about that. Has it been done? It has not. So, boy, taxes are one of those things that are right up there that you need to be paying. So you won't hear from me, don't pay your taxes, I'll tell you that much. Yeah, the other issue, though, is lease payments, right? So if you're renting a space, so I know there's lots of talk that the housing courts are shut down, right? As of whether they're actually doing evictions and whether that would apply in the commercial setting or not. So there may be flexibility with respect to that because, one, your landlord's not going to want to throw you out. Who on earth are they going to put in? That doesn't make a lot of sense. So if you have payments, try to work with them because that's an area where there could be flexibility. The government relief is coming, but boy, I get very nervous about self-help where we say, well, I thought you were going to not pay the payroll taxes, so I didn't pay them in, because they're going to be all over watching for that because they don't want situations where employees are working and never get paid. Yes, there was another question in the back, then we'll go to the front.
I gotta remember it now. What are the implications of asking for voluntary termination of work? So if we went to our staff, we have some college kids or whatnot that might just say like, hey, I'll just want unemployment right now. And what are the implications, or how should we word something like that, just to reduce workforce fast, I guess?
Yeah. So the question is, what about people who voluntarily say, look, I'll be willing to, you can fire me, right? So you have to be careful with that, because the system, the unemployment system, is not set up to pay people for quits, right? So if it looks too much like a quit, that might not be there. I think what you can be is you can be cognizant of that when you're making those determinations as an employer. I don't like the idea of going around and saying, all right, who doesn't mind if I fire them, right? And looking for volunteers, because it just creates a whole lot of issues. And one of the real serious issues is, and after the fact, well, someone felt pressured. I knew they wanted me to, so I felt I had to. No, I mean, you can think through who's your most dedicated employees, but I don't like the idea of turning it over to your workforce. That has to be the decision you own as far as who stays and who goes.
So what you're saying is that we know of zero relief for small businesses today. We know of relief of employees. We know what unemployment can do. We know potential tax relief that is zero today. And all of the burden is off of profits or nest egg of just to exhaust it and hope something gets returned.
Yeah. So the question is, what's the relief for the business community? What's the relief for small business, medium-sized business? Where is our help? And the answer is, it's not here yet. That's exactly right. You don't have the help you need. It's got to come, and it can't wait, because you have all of these burdens. Now, one could say, well, if the government really steps in and funds this and does it where they do advancements from the Treasury for this leave, that could be some help. But you don't have the relief you need. And I'm not going to tell you you do, because you're absolutely right. Businesses are not, they don't have the relief they need yet. Question over here.
Well, first thing is, I actually had our accountants check sales, the revenue, Minnesota Department of Revenue. They haven't thought about it yet, whether they're going to extend sales tax. It never occurred to them. They're working on it. Secondly, what's our liability when as we're deciding who to lay off? I would go naturally to all my part-time employees, 20 hours a week or less, or my caterers who work very sporadically. Well, what's the liability as we choose this? What's our criteria? If somebody's going to question, oh, you discriminated on us because you let that person stay, but not us.
Yeah. So again, for the video audience, the question essentially had two parts. One was a comment that it doesn't appear that the state has taken the actions they need to address the sales tax issue. Again, just another example of the business community needs the help now. But then two, as we're looking for these terminations, what criteria do we use? We've got part-time people, we've got caterers. How do we juggle who to let off and who to stay? So I think the first stage, the obvious one, is we're not going to do it based on age, disability, race, ethnicity, all of those protected classes that we never consider, we don't consider. All right, what just made that harder? We have a pandemic that affects older people more. So if you do your first in, last out, and now you have a workforce of all people who are more at risk from this virus, and there's a leave eligibility, what have you done to your workforce? So that's a difficult situation to address. But here's the fundamental question I would ask first. What's your business model probably for the next few weeks? And if it's a takeout business model or a delivery business model, then the focus is on the business reason. Who serves that end? Like, which employees can best do that task? And those are the employees who stay, and everyone else goes. So if you imagine a world where it's equal across that, then you have to just find some other criteria that you can use. And maybe it's who's been working there the longest. What it can't be is something discriminatory. So what you want to have is some reason as to how you came to your conclusion. Well, and the two most common are, this skill set is what we needed for this time, and that's why they stay. And the second reason is duration of employment or something like that. You're going to want to point to, how did you make the reason? So then there's this whole other issue that raises, and when you have large terminations of employees, then you often get kicked into this world where you have to do an analysis of the effect on all the employees and break it down by categories. I don't know, some of you are nodding your head, you may have dealt with that. So that's another thing that's out there, but it's more than we can talk about today, and it's not going to be your first thing. Yes?
Based on that, obviously you can't discriminate against age. You
Yeah.
have minors, 14, 15, that can't work past 7. That's a big part of that.
Mhm.
But can I say that because they're not able to work the length, but it is due to age?
Yes, I'm comfortable with 14 to 16-year-olds saying, look, we need some, because it's business related. There's a real business reason. It's not because you're young, it's because you're not available to work when we need you to work. Now the reason you're not available is because you're young, but it's based on work availability. And generally, while technically possible to have an age discrimination claim against someone who's young, boy, those are few and far between, and I'm not, that's at the bottom of my list of worries this month.
Last question.
One last question. So I think you've had one, so we'll go here.
If you decide to stay open and do takeout during this time, and you create a schedule that includes, you realize after you've already posted this schedule that you don't need all those people for all the hours that you've scheduled them.
Mm-hmm.
Is it okay just to say, you're cut, you're going home, or once that schedule's posted, do you have to?
Yeah, so this gets to the long issue of flexibility for employers as far as scheduling. So I think as long as the employee, imagine a world where they haven't shown up to work yet, you're pretty safe. You can adjust that schedule. What if they're there? Can you send them home? It gets a little trickier, and there may be some pay obligations. Boy, really try hard to get that info to them before they get them.
Like, cut a shift when it's low?
It's just really hard to make those changes. So can you send people once they've been home? Send them home, yes, if it's slow. There are pay obligations that, if it's slow, you can send people home.
But are there pay obligations?
There may be pay obligations, and that gets complicated.
Even in our current world where we already cut them,
Yep.
we
Yeah.
do schedule
Hourly.
people to business decline.
That's right, and you schedule that for that, right? So that's fine. You just have to work through some of those issues. I will stay until every question is answered at the end offline here, but we do have to wrap up the video.